Welcome back for our second panel of the day titled Canceling Student Debt for Public Service Workers, Military Families, and Vulnerable Borrowers. This panel will be moderated by Mike Pierce, Policy Director at Student Borrower Protection Center. Mike, take it away.
Hello, everybody. Thank you and welcome back to Delivering on Debt Relief. We are about to get rolling with our second panel of the day. Today, we're going to be focusing on, for this panel, we're going to be focusing on some really interesting papers focused on borrowers that had avenues for debt relief due to having a low income over a long period of time, or working in public service, or serving in the military, or having a disability. And I think that just to kind of open up with a little bit of framing, we're going to hear from a number of our paper authors that have really exciting ideas about how to make these systems work better for all of the people that have been promised for decades debt relief under the Higher Education Act. And I'm really excited to be joined by this incredible group of experts here, and we're going to do our best to try to keep this conversation focused on the practical steps that the new administration can take to be able to deliver on this promise for all of the people that have been in the system for a long time and have really struggled to be able to manage their student debt and shouldn't have had to do so in the first place. So first, we're going to hear from our paper authors, and then we're going to hear from a couple of other experts that we've been lucky enough to have join us here. And we're going to end this conversation, I think, looking forward to what the audience, we're really lucky to be joined with an audience full of scholars and academics and experts and lawyers and student loan borrower advocates and the people that are really in the trenches helping individuals make heads or tails of the system. And so we're going to try to leave you guys with some advice on how you can best be advocates in this really special moment we find ourselves in. I think the group of folks that are on this panel have been doing this work collectively for like a half a century. And it's really exciting to have so many people tune in and care about the guts of how the student loan system works or doesn't work. And so it is really just it's my pleasure and my privilege to be able to have this conversation with you guys today. So welcome, everybody. And to start, I'm going to start with you, Persis. I think your paper was really interesting, focused on the rights that low-income consumers have to make an affordable loan payment and what's gone wrong with that system. Would you mind kicking us off by introducing yourself, talking about your research a little bit, and just giving the perspective of the low-income borrowers that you work on behalf of?
Yeah, absolutely. Thank you, Mike, and to the Student Borrower Protection Center and Damos for putting on this event. Hi, everyone. My name is Persis Yu, and I am the director of the Student Loan Borrower Assistance Project at the National Consumer Law Center. Just a bit about us is we represent low-income student loan borrowers, both through public policy work, but also through some direct representation. And one thing to keep in mind is that over the last several decades, but in particular in the 90s, we saw a huge erosion of the safety net for student loan borrowers. We saw the elimination of the statute of limitations. We saw further restrictions on bankruptcy rights, implementation of the cutely called Debt Collection Improvement Act, which allows for the seizure of tax refunds, earned income tax credits, Social Security benefits, all sorts of lovely things. But the the Higher Education Act, does offer, in theory, at least some important protections, which many of our panelists my co-panelists are speaking about as well. And income-driven repayment is one of the key protections that is meant to help our low-income borrowers. It is both a repayment plan and a cancellation program, kind of all at once. And the theory of this program is to provide borrowers with an affordable path to repayment and ensure that borrowers are not saddled with debt for the rest of their lives, which sounds like a really amazing and lovely goal to have. Except for the fact that it's failing. And so, for a lot of borrowers, the promise of income-driven repayment has just not been fulfilled. We did some research through Freedom of Information Act request and found that as of last year, fewer than 20 borrowers. They actually couldn't even give me the number of borrowers because there's so few that might be identifying in some way. But so fewer than 20 borrowers have received cancellation through the income-driven repayment programs. And too often when problems arise, and there are many problems that have led to this, ridiculously low number of borrowers accessing the benefits, and I'm hoping that my co-panelist Shannon will talk about some of those. But too often when these problems arise, the department and the servicers just kind of shrug their shoulders and say, well, our hands are tied by the regulations. This is all that we can do. So what I was hoping to do through this paper is look at what flexibility really does exist through the Higher Education Act. And, looking at the IBR statute and the income contingent repayment statute, I think that the department has unnecessarily tied their own hands in this way, that these statutes are really much more flexible than the department has interpreted them to be, or has at least implemented them to be. And so on the highest level, we can be doing a lot more for borrowers. Some of the really striking takeaways that I took away from this was that we can be canceling loans in a much shorter period of time, that there's actually no minimum number of payments that need to be made under each of these statutes. We can, and frankly, we should be providing benefits to defaulted borrowers. The fact that the department has not implemented, but actually both of these statutes expressly allow defaulted borrowers to access the program, and we have not allowed them to do so. And we can be counting payments that were made prior to a consolidation, which is another thing the department hasn't done. So I dive into more details in what is probably a too long paper. But the highest level takeaway is that I think, we could be canceling all the loans of any borrower who has ever enrolled in an income-driven repayment plan and made as much as a single qualifying payment. And I think, that's the starting place, and maybe that's not where we wind up, but that's the ultimate flexibility of these statutes, and we should be implementing them in a way to provide the relief for the borrowers, especially the borrowers who have been struggling for the most number of years. Thanks, Mike.
Thank you so much, Persis. That was awesome. And I had to say, I really loved your paper. And I really came away from it. I came away from your remarks just being struck by how it's not really much of a safety net when we've made these policy choices to exclude the most vulnerable borrowers. And so it was really great to be able to do a deep dive into the law and to realize that the law is actually much better than maybe a bunch of the lawyers that work on it understood, myself included. So next, I wanted to turn this over to Bethany. Bethany, would you mind introducing yourself briefly? And then talk about your research, and particularly talk about what total and permanent disability discharge is, who it's intended to protect, why it's failed, and then how your vision would suggest that President Biden should take action to repair the damage.
Well, hi, everybody. My name is Bethany Lilly, and I am the Director of Income Policy at the ARC of the United States. We represent people with intellectual and developmental disabilities and their families. And I also co-chair the Financial Security Task Force for a large DC consortium of organizations that represent kind of a cross-disability set of issues. And that is very much how I come to this, from a cross-disability perspective. And that is exactly what the TPD program is supposed to, the folks that the TPD program is supposed to help. It is supposed to help people who have become disabled to such a degree that they have difficulty working and paying back their loans. It's tied directly into another program that I spend an extensive amount of my time with, the Social Security disability system, which is equally as complicated and messy. And I think we could all probably agree needs some of the same types of reforms around kind of automatic processing. But all of that being said, TPD is supposed to help borrowers with disabilities. So if you go to school and you take out loans and then you get into a car accident and end up with a traumatic brain injury or a spinal cord injury, if you went to school and you were diagnosed with MS later on, and over time it has become such, your functional limitations have increased to a degree that you can no longer pay back your loans and can no longer work in the same way, TPD is supposed to step in and help those folks. Unfortunately, the way that the program works right now includes a lot of bureaucratic barriers. And I think I'm going to build a lot on what Persis had to say about the program not really working for people in the way that it should. The number that really struck me as we were pulling all of this together was that there are over 400,000 borrowers on Social Security disability programs right now that have federal student loan debt and aren't going through a discharge process. They haven't gotten those loans discharged. And that's truly shocking to me. If we have 400,000 people that the Department of Education and the Social Security Administration acknowledge have this debt and acknowledge that they are eligible and they have that debt has not been discharged, that's a failure of the system in and of itself. And so we go through a lot of recommendations in the paper, and I would highly encourage folks to take a look at it. But I think probably the biggest recommendation that we have is automating this process as much as we can. By definition, we're talking about folks who are on Social Security disability and have difficulties working. And so those same types of skills that you might need to jump through all the bureaucratic hoops of the current system to fill out paperwork, to make sure the government has your updated income information, those are exactly the kind of barriers that folks with disabilities face because of their disability. And so that's something we really need to take into account. And I think automation would be a really big part of it. And much like Persis said, the way that the Department of Education wrote the regulations in 2012, two Social Security lawyers, and my colleague and I, who wrote the paper with me, were both Social Security lawyers. We kind of looked at the reg and we're just like, but that doesn't make any sense. And so much of our paper is kind of outlining, I don't think the Department of Education quite understood how pieces of the Social Security system work. And so outlining how they could look at other systems and or other pieces of the Social Security system and build off of those, I think will be really important going forward. And we think that the Biden administration has a lot of authority to act on this immediately. I mean, we've seen how COVID rates are impacting people with disabilities. I mean, we have some of the highest death rates, especially the population I represent right now, folks with IDD. And being able to help people who, I mean, there are people who are actually having their Social Security benefits garnished right now because they're in default on their student loans. And that is, despite being eligible, that's the part that just drives me up the wall. But yeah, so that's my short summary of our paper.
Thanks so much, Bethany. And again, it's a really interesting paper. And it's great to have a disability advocate's eyes on what has been treated for a really long time. It's like a higher education policy issue by people that don't work with that community and don't understand the mechanics of these programs. And so we were really excited to be able to feature that writing in this volume. And I hope that, I think it's all of our hope that the next administration listens to the voices of the people that are the closest to the communities that these policies affect. Which is actually, I think, a great segue to talk to you, Mike, now a little bit about your paper. We, I think, have spent a lot of time dissecting the Public Service Loan Forgiveness Program and all of its flaws. It kind of famously has rejected 98% of the people that have applied for it. But you approached the issue from the perspective of military borrowers, of service members and veterans. Would you mind introducing yourself a little bit and then talking about what your research found and your recommendations for action?
Sure. So I'm Mike Saunders. Today I am representing the Student Borrower Protection Center as a military fellow, but I have spent about the last decade advocating on behalf of active duty service members, their families, veterans and survivors in front of Congress and the executive branch. Just to frame the issue for everybody, because a lot of people think that, how much does this student debt issue affect the military connected community? And the answer is quite a bit. So recent research by Veterans Education Success has found that in the 2015-16 school year, 11% of veterans at two-year public institutions had federal student loans, 32% of veterans at four-year public and nonprofit institutions had federal student loan debt, and 42% of veterans at for-profit institutions had federal student loan debt, and that is despite having access to the GI Bill. So when combined with the fact that in 2017, CFPB reported that 200,000 active duty service members owed nearly $3 billion in federal student loan debt, numbers that in all likelihood have only gotten bigger in the intervening years, it is clear that student debt's a big deal for the military connected student community. One of the reasons the number of active duty borrowers is so large was noted by Holly Petraeus during her time as the head of the Office of Service Member Affairs at CFPB. Many of them are coming onto active duty already carrying some of this debt. They may have already attended an institution of higher learning and left before they earned a credential, and it is likely one of the factors that incentivized them into coming onto active duty in the first place. The Student Borrower Protection Center did a Freedom of Information Act request recently, thanks Tarek, Ben, and the team over there, and found that despite there being over 200,000 active duty service members owing student debt, federal student debt, only a fraction of these borrowers, roughly about 17,000, had even submitted an employer certification form indicating an interest in participating in public service loan forgiveness. Military service is the quintessential public service, and yet military borrowers are continually denied access to public service loan forgiveness. Notably, despite their clearly qualifying service, nearly a quarter of those borrowers' ECFs were denied. One of the main reasons for this is quite possibly the nature of military service itself. It can take hours on the phone with your student loan servicer to get enrolled in or to recertify for income-driven repayment. Hours that people who were deployed to war zones, under the sea for 6 months on a submarine, training at the Joint Rotational Training Center at Fort Polk, Louisiana, or the National Training Center at Fort Irwin, California. So they simply don't have that type of time. In fact, in the military, you're taught that it's a 24-hour, 7-day-a-week job. And you're told that you're on Uncle Sam's time. So one potential way identified in the paper to get at this is the HEROES Act in 2003, which provides the Secretary of Education the authority to grant financial and administrative relief to veterans affected by war, military operations, or national emergencies. In particular, the HEROES Act adds emergency powers to the Higher Education Act, which allow the Secretary to execute waivers and modifications of any statutory or regulatory provision applicable to Title IV funds as the Secretary deems necessary in connection with a war or military operation. Notably, the HEROES Act expressly permits the Secretary to authorize broad-scale waivers for classes of borrowers. In fact, this is the authority that Betsy DeVos just used to extend the CARES Act pause on student loan payments and interest accumulation until January 31st of next year. We have been a country at war since September 11, 2001. So the incoming Secretary of Education should use this authority to ensure that all who served on active duty since the creation of the Public Service Loan Forgiveness Program receive credit for their time in service, regardless of whether they satisfied the other requirements of the program. Additionally, the next Secretary should take immediate action to forgive the loans of borrowers who have served on active duty for at least 10 years or have served their communities and country for at least 10 years through a combination of military and civilian service. This could possibly be the leading edge of the executive actions the incoming Biden administration takes to deliver broad-scale debt cancellation using existing legal authorities. The military is used to being the tip of the spear. This time they can do the same and lead the way for their civilian counterparts who are also struggling under student loan debt.
Thanks so much, Mike. That's awesome, and a great overview of a really interesting paper. We're going to come back to that HEROES Act authority, I think, a couple times in our discussion today. It does offer an incredible opportunity for the Secretary to do right by men and women in uniform, something that should have happened a long time ago. But it also offers kind of a broader opportunity to seize this moment we live in the context of the pandemic. And as I think you rightly mentioned, it's been used by the Trump administration to provide immediate debt relief for tens of millions of people. So I do want to make sure we come back to that. But first, I wanted to ask you, Alyssa, to introduce yourself, talk a little bit about the work that you've been doing. You've been in the trenches at AFT for a long time, trying to help individual teachers, healthcare workers, other workers make heads or tails of the Public Service Loan Forgiveness Program, the Teach Grant Program, Teacher Loan Forgiveness. Can you share a little bit about your experience working with individual borrowers and really just try to give borrowers a voice in this discussion?
Yeah, happy to do. Thank you. My name is Alyssa Picard. I'm the director of the Higher Education Division at AFT here in DC. I worked for our state and local unions before I came to DC as an organizer and as a negotiator. So I come to this without the perspective of an attorney, which is a really strange set of tools to be lacking in dealing with student debt land. When I started in my current job, I kind of inherited a student debt clinic program that was in its nascent stages at AFT. And that program had arisen out of an effort to put together an economics curriculum for working people. The very first iteration of bringing together union members to talk about what they would want to learn about economics and about the aspects of of economics that affect them the most resulted in so much conversation about student loan debt that the rest of the curriculum was never actually created. The student debt clinic work came out of it, and we have been driving that ever since. So the context for us is that almost every one of our 1.7 million members needs some amount of college credentialing in order to hold the jobs that make them our members. And that means that many, many, many of our members have student loan debt. In higher education specifically, the 230,000 members we have who are faculty and staff at colleges and universities in this country, roughly half of those members and about 3/4 of all in the industry are adjunct. They are working in what are essentially gig economy jobs, which I mentioned to say that the predation in this system is not just on students, it is also impacting our members in their role as borrowers and as providers in the higher education system. But what's common across all of our constituencies is that there's overwhelming confusion and obstacles accessing IDR and public service loan forgiveness. The kind of nightmare story that come to us from an adjunct member in Palomar, California, is of somebody who had repeatedly applied and actually met all of the formal criteria to get public service loan forgiveness. He had the right loans. He'd made 120 on-time payments, but he ended up trapped in kind of a bureaucratic nightmare having to do with the forms that he needed to fill out. They were first rejected because he had provided an electronic signature, and he was told that he had to have a hand signature. When he sent the hand signature, he was told that he didn't have the most current form, and the forms changed again in the time when he was doing the application. So the last thing that he wrote to us about it was, I'm almost certain that they're going to reject and deny this application again, indicating that I must download the very newest form, even though both agents on the phone told me that would not be necessary. He'd spent a lot of time talking to his servicer and to the Department of Education. I fear I will have to email one school and physically go see another school to get the chairs and HR persons to re-sign the form. Unfortunately, in the middle of this, he experienced a partial layoff. So he'd been teaching X number of classes as an adjunct to make the 30 hours a week. And he ended up losing one of those classes. I'm only working at one school now. If they ask for verification of these forms yet again, I'm not working at both schools, and they will deny me PSLF on those grounds, even though I made all 120 payments working full-time between the two jobs for the last 10 years, because there's also a requirement that you be currently still meeting all the requirements for PSLF. I don't know what you can advise me or how you can intercede, but the application should be assessed on the conditions when I applied, which were last fall, teaching 2 classes per school at 16 hours per, totaling 32 hours, which is a completely reasonable way to think about what should happen to you if you're in this system. And what he was saying to us effectively was, how do I appeal a bad decision in this process? And the answer, of course, as many folks on this call know, is that there is no appeals process. I mean, you can apply again, but your application is going to go through the same process it went through the first time. And so this guy, for all intents and purposes, is living in, like, you know, the Terry Gilliam's movie Brazil when it comes to his student loan debt. Like, he's throwing forms of increasing complexity into the maw of a process that doesn't make any sense, and that's continually kicking him out rejections and telling him this is just not going to work for you. So, you know, we've all shared the experience of COVID. Our members are on the front line in that experience in some very dramatic ways. They are the people who are making the benefits of functioning government available to other people at all kinds of levels, right? Teachers and teaching assistants and public health workers and college and university professors and public health researchers, doctors and nurses, all of these folks to whom the promise was made, if you go into these occupations, you are not going to be struggling for the rest of your life with student loan debt that you can't get rid of. And that promise has been broken dramatically over and over again. That's what brings us to it as an organization, to our advocacy to try to fix the system, make it more navigable while it's still broken, and to hold bad actors accountable over the long term.
Thanks so much, Alyssa, and thanks for sharing your member story. That is probably the 10th time I've heard the Palomar nightmare story, and I feel like every time I hear it, I get fired up all over again. This is really wrong. It's not both just like legally wrong, it's morally wrong, and I think we're all so lucky to have AFT fighting on behalf of its members, because that voice is kind of so badly missing so much of the time in DC. I'm going to use a little bit of my moderator privilege here and provide a really short overview of the paper that I contributed to this series. So I'm also one of the paper authors in this set of research that we released. And I looked at the HEROES Act and the intersection between the HEROES Act and the Public Service Loan Forgiveness Program, along with my colleague, Rebecca Marr, who also works at SBPC. And we came to a kind of a similar conclusion that the Persis came to in looking at the statute and realizing just how far astray the administrations of both parties, going back to the Bush administration, have been in implementing public service loan forgiveness. And we reached that conclusion on a few fronts. One of those is exactly the kind of scenario that you just described, Alyssa. And I'm really eager to hear Shannon provide some more color around how that operates on the industry side too, as an enforcer. But people just seem to get stuck in the process of chasing paper around the student loan system. That's true for public service loan forgiveness. It's also true for all of the programs that we've all looked at in our research. And the HEROES Act really gives, so as Mike mentioned, there's this opportunity that's been in place basically since 9/11 to provide administrative relief for military borrowers who are affected by the authorization for the use of force after 9/11. But since March 13th, 2020, there's actually been a similar ability to just cut through this red tape that's available to everybody. The HEROES Act also says that in the event of a national emergency, the Secretary has this incredible authority to waive pieces of the law and waive pieces of the regulation to make the system work for people. And so the kind of a nightmare that you just described, Alyssa, seems like a great case study in the sort of things that the Secretary of Education could do tomorrow or on day one of a Biden administration to make these programs work properly, and to do that through automation, accessing data and records that are already in the government's possession, already in servicers' possession, to make sure that they're checking boxes on behalf of borrowers instead of forcing borrowers to check their own boxes and needlessly rejecting paperwork over and over again. And kind of adjacent to that point, we are in an emergency that is also a public health crisis. And for reasons that have never been clear to any of us doing this work, the Bush administration back in 2008 made a decision to exclude public health workers from public service loan forgiveness if they were working for an employer that was not a nonprofit. So our healthcare workforce, I think as all of you guys that do this work know, and so many people on the audience today know, really is kind of bifurcated. You have elite healthcare workers, like doctors in particular, that are heavily credentialed and also heavily indebted and very much benefit from PSLF because it allows them to serve in primary care, in underserved professions, in underserved communities. But you also have this frontline healthcare workforce that is disproportionately female, it's disproportionately Black and brown, and it's disproportionately employed by for-profit employers. And so by this policy choice a decade ago, we've actually excluded the people that are working on the front lines, helping people in the middle of this pandemic. And the Biden administration has this incredible opportunity to take a fresh look at that set of requirements and restore the promise of PSLF for the people that are putting their lives at risk, helping us get through this moment that we're in. So I just wanted to give a plug for our research too. If you're interested in learning more, you should check it out. But I want to keep the conversation moving forward. And I do, Shannon, want to give you an opportunity to talk a little bit about your background as a public enforcer, what you've learned bringing student loan servicing cases, and a little bit about the intersection between industry practices, the government bureaucracy, and the law.
Yeah, thanks, Mike, and good afternoon, everybody. My name is Shannon Kavanaugh. I'm the Deputy Division Chief of the Consumer Protection Division at the Massachusetts Attorney General's Office. And my office has been a leader in protecting student borrowers. And today I'm going to specifically talk about student loan servicing actions that my office has taken. We both can bring enforcement actions and conduct investigations under our power under the State Consumer Protection Statute, Chapter 93A. And we have done so. We brought, I think, the first state AG lawsuit against the Pennsylvania Higher Education Assistance Agency for its failure to administer the public service loan forgiveness program. And we also brought an investigation that we settled several years ago with Xerox Education Services, formerly known as ACS, focused around their handling of the income-driven repayment plans. But we also have a unit in our office, the Student Loan Assistance Unit, that is hearing directly from individual student borrowers. And they have fielded thousands of complaints and inquiries from Massachusetts student borrowers. And what's important to note, and I just echo all of the views and points that my colleagues here on this panel have made so far. But what's really important to note here is when student borrowers individually contact our office seeking help, it's because they've exhausted all other lines of communication. They have already been in touch with their student loan servicers. They have already spent a lot of time and energy trying to figure out these problems themselves, trying to get basic information, not only about the programs that are best suited for them, but also basic information about their loan accounts and the status of their loan accounts. They've oftentimes been through the Department of Education's ombudsman's office. And so there's a huge failure here, both on the servicer's part and so far in the last several years on the department's part to do their job to make sure students have basic information and access to information in order to navigate the system. One of the things in our work here that has been really, really difficult when you ask, why things are so bad. Our office has gotten such incredible resistance from student loan servicers and the Department of Education when we have tried to get involved to advocate for student borrowers and to try to fix and assist to make systems better and programs more available for borrowers. In litigation, there's been very aggressive litigation. Just by way of example, when we did bring our lawsuit against FIA, the Department of Education, that was not a party to our lawsuit, stepped in at the 11th hour, a day or two before our motion to dismiss hearing, and showed up uninvited. The Department of Justice walked into the courtroom and they had filed a 30-page statement of interest on behalf of the Department of Education, arguing that our complaint was preempted. But they couldn't even make that argument in the statement of interest. They said, to the extent the Commonwealth is alleging X, then it's preempted, because we didn't allege the things they said for the very purpose of avoiding preemption arguments. So we're just hit from all sides in trying to make progress on these issues in litigation. The fights with respect to preemption, Privacy Act arguments, where we're trying to get basic borrower level information in order to be able to review it and identify where things went wrong to get relief from borrowers. We've just had so many walls thrown up at every angle. So one of the recommendations that I have is going forward, hopefully we'll have a much more collaborative relationship with the Department of Education in order to be able to bring some accountability to the system. But the other point that I'd like to make that we've talked about a lot today is the borrower burden. And I break this down into two types of burdens. There's the administrative burden that a lot of folks have talked about. When I hear stories about forms, my blood pressure goes up. It's, when I explain it to people, people usually can relate, even if they've never been a student loan borrower, to their worst customer service nightmare. And I say, well, what if that worst customer service nightmare can lead you to financial ruin? And that just, exacerbates this problem so much, because when borrowers are making these choices, for example, to participate in public service to help our communities, and they look to programs like the Public Service Loan Forgiveness Program to ensure that they can be financially successful, the choice they're making is twofold there. It's not only to participate in public service, but is to make a very dangerous financial decision that many people outside a promise of loan forgiveness would never recommend a consumer to make in any other financial transaction they do, which is to not make payments that amortize your loan. And so when you participate in this program and you're making payments under an IDR program, then your loan balance is ballooning. And if you can't make it to the end of 10 years, and I'll get to this later with some policy suggestions, then you're ending up with debt that is significantly higher than what you took out in the first instance. And there is your financial ruin. It's not simply that you haven't made progress in what you borrowed, you owe a lot more. So it's very dangerous. So these administrative burdens with respect to forms have severe, severe consequences. But the other burden that borrowers face that's extremely important, and that's why everybody's work here is so important, is what I would call an advocacy burden. The work that borrowers have to do to figure out when something isn't right, what went wrong, why it went wrong, and to get relief is, and I think Mike mentioned this earlier with some of the military servicemen and women, it's a full-time job for borrowers to have to figure this out. And I have heard directly from borrowers, and these are borrowers that have degrees, these are lawyers, these are people who have resources to figure this out, that have taken so much time and energy and they can't get relief. And that is because they can't get information. There's a lack of transparency. They can't, and I'm not even talking only about what we would consider to be unfair and deceptive acts and practices. I'm talking also just very generally about errors and a failure of communication and a lack of transparency. And borrowers are put in a position where they have to navigate the system that they're not privy to how it works. They don't know what the internal operations of their servicers are. They don't know when they call up to say, hey, you might have, put my form in this IT system over here and failed to date it correctly. So instead of showing up, as my IDR plan starting on December 1st, it's going to show up on March 1st. And they're just not in a position to get errors corrected. So another recommendation that I can talk about in more detail later, which would be a kind of retroactive fix to the current program as it stands today, and I'm talking about PSLF, but also IDR, is hire an independent auditor to get in, look at these accounts, do a full-blown audit, identify errors, and then correct those errors, correct them to the benefit of borrowers, and take the burden off borrowers to have to try to go in month by month to figure out why they missed each qualifying payments. It's clear that these loans have been misserviced. And when one error happens on a live loan with these programs that are already so complex, there's a ripple effect, and it causes another one and another one. So the whole paid ahead status, you get overbilled one month, so you pay twice and you get put into paid ahead status. That won't count as a qualifying payment towards PSLF. There's no way that a borrower has control over that situation. So I would say, again, why things are bad. There's a lack of auditing. The Department of Education should have been more involved over the last several years in auditing and more extensive auditing and oversight and limitations in servicing systems. There are frequently IT glitches. By way of example, when Ed tried to roll out the IRS tool a couple of years ago, the software system didn't work, so people couldn't automatically get on to IDR, and they suffered delays and they lost qualifying payments. It's all well and good. We should be trying to automate processes more to avoid errors, but that's going to cause glitches. And that's okay if the glitches get fixed and the errors caused by the glitches get fixed as well. And instead, borrowers are just required to come forward and advocate for themselves. And at the end of the day, the current Department of Education does not permit loan account corrections for every type of servicer error that might have occurred, even if that error is undisputed in the context of PSLF. And even where, in our view, there's been an outright unfair and deceptive act in practice, like a misrepresentation, there is not a fix that the Department of Education will necessarily provide for borrowers in order to get their qualifying payments back, depending on the type of misrepresentation. So that's another recommendation, which is to have a much broader view of errors and when borrowers can get fixes and what those types of fixes can be.
Thanks so much for that perspective, for helping us understand the difference between consumer protection enforcement and the kind of policy change we're all calling for at the federal level, and for giving me the term advocacy burden, because I think that really captures a lot of the work that that all of us do. And maybe I'm going to just turn that to the rest of the group. I think grabbing on to that concept, do others have thoughts on where you see the programs you're experts in having this kind of disproportionate advocacy burden that could be overcome through smarter rules or better federal policy?
So maybe if I can jump in on that, and certainly, you know, one of the things, in terms of this information gap that folks have, right? Like, one of the issues that I try to address is that folks don't know that income during payment is an issue, right? And our system relies on borrowers to be experts at the student loan system in a way that they just physically can't do. And our system forgets that you don't know what you don't know. And so we work with borrowers time and time again who don't know that income during payment is an option, right? So, you know, the typical borrower that we see has deferment forbearance, and then they default, right? Because they've run out of deferments and forbearances. And so they had to interact with their servicers in order to get these deferments and forbearances into place. And yet they weren't given the tools in order to access the program that actually would have done them some good. You know, I just this morning was emailing with a legal services advocate whose borrower had been in this deferment repayment limbo since 2006. They have stayed in good standing since 2006 and have never accessed income during payment. Like, I don't even understand how they have not run out of you know, deferments and forbearances in that time frame, but that's a story that was just this morning. You know, like, we could talk about last month, the stories that I heard, but borrowers just don't know what they don't know. And the people who were paying, you know, hundreds of millions of dollars in order to tell them aren't getting that job done. And I think it does take, I know for myself, right? Like, when I have had problems, I'm actually, I think, a member of one of the AG's suits that they're doing, but, you know, it took me 7 months to get my loans out of IBR and into repay. And in that time frame, right, like my loans were in an administrative forbearance, they slipped into delinquency. Like I probably logged about good 40 hours to try to get that fixed. And who has that time and that knowledge to know, right? We write a book on student loan law, and so I'm fairly well versed in how the statutes work. And it took me 40 hours to move through the process and get that fixed. And so I think that that's why, just to Shannon's point of, the advocacy burden is just too much for borrowers to actually reasonably go through themselves.
I think if I could just add, to sort of make explicit what's implicit in that pattern of deferment, forbearance, and falling into default, there's also tremendous psychological burden associated with this. There is enormous shame for people around their student loan indebtedness. There is particularly huge shame around parent plus loan indebtedness, because parents have got giant feelings that come from completely understandable places about the fact that they were not able to do the thing that they were told they were supposed to be able to do and pay to send their kids to college as a lever of class mobility in the first place. And so when people are trying to overcome these advocacy burdens and make the time and the space and secure the knowledge to advocate for themselves, they are also pushing uphill against a really, really powerful set of disincentives. One of the things that we found helpful in the debt clinic program at AFT around it was just that people were in a room together, and the way our clinics are set up, people get information for like the first 45 minutes because they have to be talked to about the fact that it's not their fault, and like get comfortable enough with receiving all the information about how the system is broken before they're willing to start kind of popping up and saying like, this happened to me, and being angry about it. It helped a lot to mobilize people. And I think this political moment of talking about cancellation is doing some of that work even for people who aren't in a room together. Because even if you just catch, on the front page of the New York Times today, somebody's talking about debt cancellation, it gives you a sense of like, wow, something like maybe this isn't just me. Maybe this system is really messed up. And I think that's part of what makes this moment so powerful.
Go ahead.
No, go ahead, Mike.
Oh, sorry, Bethany.
Just to piggyback off of what everybody's saying, I mean, the conflicting incentives that people have, if you have the wrong type of student loans and you're trying to get into PSLF, you would theoretically consolidate with a direct consolidation loan. In the military, if you have those student loans prior to joining, you have Service Member Civil Relief Act rights that are that go away after you take out that consolidation loan. So that you have to choose between having an interest rate cap on your student loans while you're in the military, like Congress intended, or participating in PSLF while you're in the military, like Congress intended. There's literally a no-win situation there for them. And I know, speaking of individual examples, I know of another individual who has been out of law school for 23 years, has worked for the Army probably the entire time, but consolidated his loans before PSLF came into effect. So he is locked out of PSLF and is just the quintessential person who should have had their student loans forgiven before. So it really does cut across the entire federal student loan borrower community.
And I'll just add that oftentimes the information is already there, and you are being asked to submit information that the government or the servicer already has. I experienced that personally as well, but for folks who are on Social Security disability, they already report their income every month. It's not actually like they're used to filing paperwork. By and large, they do that with help of legal services attorneys or have regular processes there. And then to turn around and have education ask them for that information again it's frustrating for me when education's like, hey, can we check with the IRS about something? But at least I understand they're asking for my permission to share information when it's already information that everyone has, and Ed and SSA are already sharing all this information. The fact that they can't just use the information that they have to automate the process and to make it simpler for everyone involved is does not make any sense. And anything the administration can do to simplify that is going to be a huge step in the right direction.
I think that's a good segue for my next question. So everybody who's written papers here, but I think all of you that have kind of worked in the trenches on these issues for so long, had really good, concrete, tangible advice for specific steps the Biden administration can take to drop these administrative burdens, to automate the process, to help reduce the advocacy burden on borrowers. So maybe we can go through anybody that wants to jump in, the one piece of advice that you would give to the Biden administration right out of the gate to help your constituency make heads or tails of the system.
I mean, I think you have to get agencies to talk to each other. That has been, I think, the barrier for so many of these programs, right? We can't automate, annual recertification of income-driven payment because the IRS and the Department of Education won't talk to each other, right? It took a lot of work to get the Department of Education to talk to the Social Security Administration and to the VA, right? But it did happen, and so that's actually, I think, I don't know if we want to call it the promise, but certainly like it's possible. And so they just need to, and I think it needs to come from the top. I think it probably does need to come from the White House to say, this is a priority for agencies to actually talk to each other, which doesn't seem that radical when I say it out loud, but truly is one of the barriers in terms of getting a lot of these processes just to frankly work.
And we need them to follow the statute. I mean, with the TPD program, it's very clear. As long as you have been on Social Security disability for 5 years, you meet the statutory standard. But there are people who have been on SSDI for decades who aren't getting their loans discharged. That makes no sense. And we need to take a good hard look at what the statutes are and go back to what that is. And we're in a very unique moment with the authority under the HEROES Act and the pandemic right now to help all of these low-income borrowers who will put the money directly back into the economy and start motivating that type of spend that we need to get the economy running again.
Yeah, and I would say, specific with PSLF, go back to the legislative intent. Go back and look at the legislative intent. And if a borrower is working in public service and making student loan payments, that borrower should be getting the benefit of PSLF under the current program. But the program should be looked at, in my opinion, prospectively, to think about the 10-year requirement of the program. And I think that loan forgiveness, if there is going to be a 10-year requirement before you finally get loan forgiveness, and maybe it should be a shorter period of time, but if they are going to keep a 10-year requirement, loan forgiveness should happen incrementally. Borrowers should not have to just wait until they've made it through all the minefields and 10 years later find out for the first time whether they're going to get the benefit of the promise of the program. They should be getting incremental loan forgiveness either on a yearly basis or even better on a monthly basis. That's what qualifying payment is. You're making payments towards loan forgiveness so that these loan balances, they don't have the burden of having these loan balances grow with the stress of trying to navigate the system, and they're performing in public service. It's valuable every month they perform in public service. There should be some kind of benefit there, which is what the intent of public service loan forgiveness program is. It's encouraging people to come and to make a commitment. And whether that commitment is 1 year or 10 years, it's still benefiting our society. It's still helping the people who need the most help in our society. And there should be, the program should be geared towards that goal.
And I think that's a great segue to the political moment that we're in right now. So my colleague Tarek mentioned on the first panel today that we have a president-elect and a vice president-elect that expressly campaigned on providing debt relief to student loan borrowers. And exactly the kind of policy change that Shannon just mentioned on public service loan forgiveness, that was in the Biden campaign platform. The Biden-Harris campaign proposed offering public service workers $10,000 per year for working in public service for the first 5 years of their public service as a supplement to the existing public service loan forgiveness program. I think when that particular provision was announced, it was anticipated that would be a legislative change. But one of the things that seems to me, at least, like the real opportunity that we're in is that you can make those kind of restructuring decisions, particularly if you're doing it backwards looking. If you're going to take that framework and use it to repair the damage that's already been caused to the public service loan forgiveness program, we should look to what the president campaigned on and the president-elect campaigned on, and we should try to kind of use our imagination and use the law to be able to deliver on that promise. So I do think it's really it's exciting that we have a president-elect and a vice president-elect that campaigned on fixing these programs. Like this very wonky, arcane piece of student loan law that we all live in was front page news for a while. It continues to be front page news, and that's a real opportunity for all of us. So I think maybe to round us out here, we have an audience of scholars and activists and student loan lawyers and individual borrowers that have now tuned into 2+ hours of a very detailed conversation about how to fix the student loan system. And we still have hundreds of people that are joining us for this discussion, which is incredibly exciting. Can you guys give some homework out? So to the scholars, to the activists, to the advocates, to the lawyers, what are the things that they can be doing to help push this forward, to give President-elect Biden and Vice President-elect Harris the tools they need to be able to take action? What's missing from the public discussion? What research needs to be done? What lawsuits need to be brought? What stories need to be compiled? What comes next?
I'll go first. So, frankly, the absolute numbers of active duty service members who have student loans. I mean, we don't. The best we have is what I said earlier was a CFPB estimate from roughly 2017, and they had to do some serious forensic analysis to come up with that number. So the secretary should match student loan records against active duty service records already available to Ed, so that military borrowers can receive their PSLF credit. Yeah, we just don't even really have the full idea of how big a problem this really is.
If I can piggyback off of that suggestion, like one of the things that we don't actually know. So part of my paper, what I tried to do is kind of come up with categories of people who we should dig back through our records and figure out we can dole, forgiveness out to or cancellation to these borrowers immediately on day one by looking backwards. But we actually don't have a lot of information in the public sphere about these loans. And some of the things we don't know is like, what is the point? What borrowers never repay their loans? Like, it seems to me that there's a pool of borrowers for whom it makes no sense to continue to collect on their loans for 20, 25 years. So we need more data about the characteristics of just the student loan portfolio so we can start making better policy decisions. And then, I think we need to think big too. Right? Like, let's not have this conversation in a vacuum. It has in the cancellation, right? Like, we're in a cancellation moment. We should have widespread cancellation. We should be working towards a, debt-free higher education policy. And so, I think that income-driven repayment is critical until we solve those problems and eliminate student loan debt altogether. And then my last plug is that just don't forget Parent Plus borrowers, because they get left out of the conversation, and it is one of the populations that I struggled the most to figure out how to get them included in a cancellation program. So think about Parent Plus borrowers.
And building on that, I'd love to see numbers for retirement Social Security beneficiaries who are still have student loans or Parent Plus loans pending, because I'm sure there are lots of them, and I tried to find that number and I couldn't. And the OIG office at Social Security has pulled some of the ones that transition from disability to retirement, because you can kind of do that math. But I want to know how many retirement are, because I'm sure that those folks, I mean, if we're going to target another population, that's a population that are by and large very low income, or relying on very limited means. And yeah.
I feel like this is giving myself homework a little bit, but to the other, enforcers and litigators out there, to make a real, there's so much secrecy. There's so much just hidden from the public view. And we have the benefit of discovery in our cases and in our investigations. And to the extent that the battles can be fought and won with respect to confidentiality and getting as much discovery and information that we can out on the public record, so that there is no longer this, secrecy. What's the contract that the Department of Education has with the servicers, by way of example. There's information, to be had that litigators have a special tool for being able to obtain. So to the extent as much of that can be made available publicly, we should be working to do that.
I think I would like to just kind of underline and amplify what Persis said, which is that, we have this opportunity because there were roughly 8 million more Americans who wanted to double down on democracy than whatever the heck we were headed for, having not done that. But we cannot have the kind of democracy that we want to have in a system where all of our higher education costs are privatized and turned into debt. It's just not, it will not work. So this has to be, this conversation about cancellation and about student loan indebtedness has to be tied to the conversation about how we're going to pay for higher education going forward. And it's actually one of the things that excites me about it the most, is that I think any amount of cancellation, whether it's 5, 10, 50, or all of it, is going to help push people toward having that larger conversation about how we don't have the same problem again going forward. So I want to invite everybody who's listening into that conversation about how are we going to undo the privatization of higher education costs in the future.
Those are amazing concluding thoughts from all of you. And I want to thank you all for joining us for this discussion today. Thanks for tuning in to everybody that's watching this panel and our program at large. Check out the papers that everybody wrote. They're available on protectborrowers.org. Thank you again also to our partners at UCI Law for working with us, and to Demos for co-hosting this event with us. And we will be back in just a few minutes with our last panel of the day. So thanks, everybody.